Prosecutor's Office, and we're talking about the investigation into the Broward County's Community Action Agency and the allegations of falsification of official documents. Tell us about this case, Mr. Schulson.
Okay, briefly, as a result of a citizen complaint early in 2008, which actually came from an article that you had written in the newspaper, we looked into a matter involving a former county employee named Jacqueline Kassower. She had been the executive director of the Broward County Community Action Agency, and she had falsified minutes of meetings of the Broward County Community Action Agency's advisory board. And as a result of fabricating minutes of meetings, she was given the choice by the Broward County administration of either being terminated or taking an early retirement. So within 24 hours of being given that option, she chose to retire, and that happened, I believe, in early September of 2007. We didn't receive the notification of this directly from the county. As I mentioned before, we received it from a citizen, Joe Major, who again provided us with a copy of your article. So as a result of that, the investigation opened up, and as a result of the investigation, Ms. Kassower was eventually charged with one count of falsifying public records.
And she committed multiple acts of falsifying documents. Explain why the single charge was necessary in this case.
I think there were a couple of reasons. What had happened is, as a result of Hurricane Wilma, and just to be brief, there had been severe relocation of the Community Action Agency, and she was focused on keeping the agency together during those tough times. But in the summer of 2007, I believe late July, she received notification that an audit was going to be conducted by an official from the state Community Affairs Department. And one of the requirements of this audit was to produce minutes of advisory board meetings. But since Wilma, essentially, there had been no advisory board meetings, so she sat down, I guess over a matter of a few days, and she falsified minutes from at least 3 or 4 meetings which had never taken place. And I just felt that, and part of my investigation was also to make a determination whether any money had been taken, had been stolen, and I found absolutely no evidence that Ms. Kassower or anyone from the agency had taken any state or federal funds. And I felt that based on her 18 plus years with the county, it had been excellent, all her reviews had been excellent, that a fair resolution would be 1 count to include the falsifying of minutes of several meetings in 1 count. It wasn't going to have any effect in terms of the ultimate resolution of the case. So between her stellar career, she had made an egregious mistake, and she had paid a price for it by being forced to take an early retirement. She now is being charged with a criminal misdemeanor, and I felt in the overall picture this was a fair resolution. There was no reason to have multiple counts when it wasn't going to change what the ultimate resolution was going to be.
And you took her statement in Las Vegas. Why was it necessary to travel to Las Vegas?
I had had phone contact with Ms. Kassower when I commenced the investigation, and she informed me that she had relocated to Las Vegas. She was having some financial problems, even though she had been able to obtain employment there. She was unable to afford an attorney, but she said she had no problem discussing in detail with me exactly what had happened in this particular case. She said her life was an open book, but she didn't have the funds to travel here, didn't have the funds to hire an attorney. So I just got on a plane and went out to Vegas, and she voluntarily appeared and provided me, I believe the statement, it's probably a 2-hour transcribed statement that was ultimately produced, where she talked in detail about how this had happened in her career and her days as the executive director of the agency, especially after Wilma, and what led to there being no advisory board meetings. But that was basically it. It was just out of convenience. She couldn't afford to come here, and a decision was made I would just go out there and get this statement taken, which which I did.
And finally, what was the amount of the fine, if you have that in front of you, that she was required to pay?
She simply she entered a plea via the mail, and she was assessed by Judge Murphy, a county court judge, $273 in costs. Because of her financial situation, it probably took her 5 or 6 months before she finally came up with the $273, which she finally did, I believe, sometime. I have to look up the date, but it was maybe the third week in March. The clerk's office finally received the $273 and the executed plea form, and so the plea was then taken on March 20th by Judge Murphy.
And therefore, the case is now closed and concluded.
Case is now closed and concluded.
All right, thank you, David Schulson. Elgin Jones reporting for the South Florida Times from the Broward County State Attorney's Office.